What's up, y'all? Welcome to the Shontavia Show, where my goal is to help you start a business based on your life's vision. This ain't gonna be your daddy's business advice. I'm laser focused on entrepreneurship in the 21st century, vision, and breaking the traditional mold. If you can get with that, you can get with me. Be sure to visit Shontavia.com for more episodes, blog posts, and other content. Thank you for listening. The show starts now. Hey everybody, I'm Shontavia Johnson, and this is another episode of the Shontavia Show, where I want to inspire you to build a brand, business, and life that you love. And everybody, I am so excited to have Nichole Hayden here with me. Thank you for being here.
Thank you for having me.
Nichole is an amazing and dynamic lawyer. I'm going to read her bio. I just had to say that first because she is wonderful and a partner at Nelson Mullins Riley Scarborough, where she focuses on intellectual property law, including helping clients protect their brands and IP assets. Nichole is a registered patent attorney. Her practice involves global patent and trademark prosecution, opinion work and strategic planning, as well as licensing, transfers, due diligence, and the like. In addition to her experience as a patent attorney in a law firm, Nichole has served as general counsel to a startup software company from 2012 to 2015. Welcome.
Thank you.
So excited you're here.
I am really excited to be here.
So you've been practicing IP law for how many years?
15 years.
15 years.
Maybe going on 16 now. I'm not sure now.
Well, so do you ever see anything new? Is it all new every day?
It's all new. Every day it's new.
Every day is new and different.
I mean, I might be in a certain technology for a while until that technology shifts and, another client comes along and you get in depth into that technology. But, the day-to-day is always different.
Always different. Mm-hmm. Gosh, so 15 years, everything's different, or things are different a lot. That sounds fun.
It is fun.
Sounds like a lot kind of know. It's a little shaky on me, Nichole. So, Nichole, why don't we talk a little about your background, where you're from? How did you get even into IP law? What's your story?
Yes, my story is a weird one. I had no background in anything to do with the law, no lawyers in my family, did not grow up. I mean, I knew a couple lawyers at church, but that was about it. Mm-hmm. And when I graduated when I was getting ready to graduate from college, I went to Barnes & Noble, and I was looking at some GMAT books in the little section for professional schools. And this retired patent lawyer was in that area, just kind of sitting reading a book, and he came up and started talking to me.
Really?
Yeah. I mean, this totally random situation. And he said, what's your degree? And I said, chemistry, but I know I don't want to be a chemist, so I'm trying to figure out what to do next. And he's like, well, have you ever heard of patent law? And I said, no, I have no idea. I was like, I knew what a patent was generally, but I didn't know anything about it. So he sort of gave me the 5-minute spiel on it. Enough that I left Barnes & Noble that day with an LSAT study guide.
Really?
And I went home and I started studying for the LSAT, and I thought, well, if I like law school as much as I like studying for the LSAT, then this is going to be a good fit for me. And it turned out it was. So
in Barnes & Noble.
I'm not kidding you. This is like my guardian angel. He's out there somewhere, or he may have passed by now. He was old and retired, and but something told him to talk to me, and for some reason I followed my gut, and
wow,
it is a story in trusting your instincts, and so it worked out.
Huh.
Yeah,
and you didn't get his card. So.
I didn't. I have no idea who it was.
Wow, that is really fascinating.
Yeah.
So you started studying for the LSAT, ended up in law school. Was it a huge transition from chemistry to law, or was it?
It was scary because everybody else. Well, it felt like everybody else had poli-sci or English degrees. So it was scary getting into law school because I had this chemistry degree and I was weird compared to everybody else. But as it turned out, the way that you prep for law school, I feel like fit really well with the analytical nature of a science degree. So ended up, it wasn't as bad as I thought it was going to be, but I studied my butt off that first semester because I had no idea what to expect.
I felt that way too, because my background was bioengineering. I didn't know anything. I didn't know a plaintiff from a defendant.
Right, me too.
So I just studied harder than everybody else, and it paid off.
It works.
Yeah, so you went to Drake University Law School.
I did.
And so Nichole and I have so many weird...
It is so, yes, our paths have crossed so many times.
Yeah, in so many ways. So Nichole was a student at Drake University Law School. I started my my academic career as a law professor at Drake University Law School because of you, actually. In
Really?
part. So when so we worked together at Nelson Mullins many years ago too. When I left Nelson Mullins and started teaching in a temporary capacity, I interviewed at Drake. They only called one reference, and I had not listed you as a reference, but you were the only person they called.
Oh, that's funny.
Yeah, and the person who's now the dean, I think, talked to you, and he said, "Oh, she said wonderful things about you, so we knew, you'd be great."
That's awesome. Yeah.
So that is how
It is a really small world.
It is such a small world.
Yeah.
Yes, and so when you started practicing, did you start at Nelson Mullins,
I did.
Or did you?
Yeah.
Okay, so
right out of law school.
You started at Nelson Mullins. We're a great lawyer. Even then, I remember because I was a few years behind you. I used to look at you and think, "Oh, I'll never be as good as her at any of this stuff."
So not true. So not true. And now you've gone and done like a million other things, and I'm still at Nelson Mullins.
Well, you've done a lot of things too, right?
Yeah.
So started at Nelson Mullins. Did you start out in patent prosecution only? Did you do other things too? What was...
At Nelson Mullins, as you probably remember, they kind of train you to do both. So you do a little bit of litigation, you do a little bit of prosecution, you learn both sides, and then you pick your path. And so for me, it worked better on the prosecution side. I enjoy the predictability of it. I enjoy knowing my deadline 6 months out. I do not enjoy surprises in the respect of you're going to be working all weekend because this litigation issue just popped up. So for me, the prosecution route is a lot of fun. I enjoy helping people sort of figure out where their IP exists and then figuring out how to protect it. And that's basically the core of my practice.
Yeah. So can you explain a little more about prosecution, about what that means?
Right. So that's a weird word when it comes to the law because everybody thinks of criminal prosecutions, but it's basically filing a patent application or a trademark application or a copyright application for that matter, and just babysitting it through the process, going back and forth with the patent office and the trademark office and arguing in favor of your client and, sort of crafting the patent or the trademark to meet the requirements of the office, but also protect the person's invention.
So you do that a lot, right?
Lot, yes.
And do you work with small companies and individuals still, or is it a lot of large
I do have a lot of large entity work, but I enjoy the small work. We do I don't know like on a percentage basis, but we do a lot of the startup work. The startups are really exciting because the client is really excited about the product. Yeah. They're really, it's an innovation that they've put a lot of research and a lot of work into and a lot of emotion and heart into. And so when one of those takes off, not every single one is going to take off, but when it does, it's great. And it's a different experience to kind of go along that process with the client.
So when people come to you, do they have any clue about what this looks like? So it's not like you go to your lawyer, they file a patent application, and you get it the next day. Is it a lot of education? Are there things that clients or potential clients should know when they're reaching out to a lawyer about the whole process? Yeah.
So in terms of the length of time and that sort of thing, it is a long process for patents at least. For trademarks, much shorter. You can get a trademark between 4 months and a year to get from the point of filing to the point of registration. And the protection goes back in time to the time you file it. So trademarks are pretty straightforward. Patents are so unpredictable. It completely depends on the art unit that you're in, the type of technology that you're in. It depends on, there's certain ways to file where you can get to a resolution faster, which are obviously more expensive, but there are options to do that. But in some cases, 2 to 5 years. I mean, obviously we've had some that have gone longer than 5 years. The shortest is about a year, and that's usually going to cost extra. The patent office charges some crazy amount of fees, but they get it done. Whereas if you don't go that track one, it might take 18 months to 2 years before an examiner ever even looks at your application.
Wow. So for people who have ideas or have invented something or have some brand that they want to put out in the marketplace, what kinds of things should they be thinking about before they even come to a lawyer? Or what should they be doing?
So documenting, number one, obviously documenting your dates of invention and all of the process that you've gone through, making sure that you've got your chain of ownership in order, to the extent you've involved anybody else in this process, making sure that any of the ownership issues are worked out between the two of you, which may involve getting an agreement in written form from a lawyer, making sure you're protected under a non-disclosure agreement if you're going out and talking to anybody about it. First and foremost, early is the best approach for patent protection. Once you have publicly disclosed it, sold it, basically put it out in the public realm in any way, even public use, you've got 1 year in the United States to file a patent application. And if you don't file it within that year, it's an absolute bar. And a lot of people don't realize that. And so we will get questions from time to time about a product that may have taken them 2 or 3 years to get some traction on, but now it's rolling, and now they want to get a patent or a patent on this invention, and it's too late. And that's really unfortunate.
Yeah. So if I have an invention, I have completed the invention, it's sitting on the shelf or sitting on my laptop or whatever. At what point do I reach out to a lawyer? Is it right away? Is it before I'm finished? At what point would you suggest reaching out to a lawyer, to a law firm, to talk about protecting an invention?
It kind of depends on your resources. In the case of the larger companies that I work with, it's usually at the point of conception. So whenever they come up with the idea, and just paper and pen draw it out and put the idea.
Not even finished yet.
Right. No, not even a prototype. They will come with a pen and ink drawing, and we will get started on that. You may not have the resources as an individual inventor, as a startup, to do that right away. But certainly before you go to market, before you get into the public disclosures aspect of it, you want to talk to a patent attorney at that point in time.
So how much does it cost? Can you give some broad parameters around that?
Yeah. I mean,
I know it's
hugely variable depending on the technology. So if it's something on the very simple end, a mechanical device that's not overly complicated, you may be in the $5,000 range. More complicated mechanical workings, inner workings, maybe kind of closer to the $10,000 range. When you start getting into really complicated software applications, sometimes that can get up even higher, like $15,000 range. It's not a cheap process, and that's the part that's hard for startups, is that you've got to be able to balance that with obviously making money. And in the beginning stages, that's hard.
Right. And that, I think that tracks with the most recent averages, the AIPLA, the Association of American Intellectual Property Law Association. Most recently, they do this data research every year. And I think the average patent application in the U.S. is like $7,500. But it's a lot of the smaller, applications, balancing out the software patents and that kind of thing.
Right, it is. And there are options to get you some, I won't say protection, but to at least cover your bases, like the provisional patent application. So if you can't afford to do the $5,000 or the $10,000 application right off the bat, provisional patent application is always a great idea, because that's really inexpensive. You can kind of scale it based on the amount of disclosure that you get from the inventor. So if the inventor is willing to put together a document that spells out how this thing works, maybe some AutoCAD drawings, whatever they've got in that vein, and we can package it up and file it, it basically puts a line in the sand at the patent office. We invented this as of this date. And you've got 1 year then to go out and market it, and to just, disclose the heck out of it and see if you get any traction. And if you do, at the end of that year, you come back and say, okay, we're ready to move forward with this patent application. We're ready to pay the real fees for this to really get, drafted in the right way. So that's something we do a lot with smaller companies.
So provisional, on average, what is the cost of a provisional?
So the filing fees are the biggest savings there. I think you can file as a small entity, I want to say $100 is the filing fee. So if you do all the work on the front end, you as a not the patent attorney, and your filing fee is only $100, I mean, you're looking at, for me, I will scale basically to whatever the person's budget is. If you want me to spend $500 on it, we'll do that. If you want me to spend $2,000 on it, we'll do that. And we'll just basically do whatever we can do within that budget to get it filed, just so you've got that line in the sand.
Yeah, so that's what you see a lot on like Shark Tank. People come in, they say, "Oh, we've got a provisional patent," but it is not a patent.
It is not, and that's why I say you're not protected. You've got basically like a placeholder at the patent office, but you don't really have any protection at that stage. But if you're willing to pursue the protection, your protection goes all the way back to that first time that you filed.
Right. So we've been talking a lot about inventions, which are protected by patent law. There are other types of IP, and it sounds like you do a lot of patents, but then also some of the other types of IP. Could you walk through a little the trademarks and copyrights, what the processes look like there?
Yeah, absolutely. And one of the things I should point out, too, is when we're looking at whether to patent something on the front end, we also want to look at trade secrets, because if your invention is something that can be easily protected by a trade secret, that's free. There's nothing. There are procedures that you need to go through, and there's protection internal that you need to observe, but there's no fee associated with it. You don't have to file anything. And a trade secret is most appropriate for an invention that cannot be reverse engineered. It's, a recipe for something, or a formula for something, or a method of making something that's faster or more efficient or more economical or better for recycling, or, recyclability, whatever the case may be. If it's something that somebody can't take apart and put back together, then trade secret may be the best form of protection, and that's free.
Like Coca-Cola's secret recipe, or
the
KFC.
Most famous. KFC's formula for their batter. Yeah.
Great. So trade secret as an alternative to patent protection, which requires the inventor or the entrepreneur to take some steps, but there's no affirmative document that needs to be filed.
Right. Yeah, but if you do go down that road, you do want to make sure you're protecting your trade secret as a trade secret. So you probably want to talk to a professional and make sure you're putting the appropriate measures in place to prevent third parties from having access, to prevent employees from having access unless they have to have access, unless they're on a need-to-know basis type of thing. Segregating who has access to certain information so that one person doesn't have access to everything. So there are a lot of procedures you can put in place internally to make sure your trade secrets remain trade secrets.
Got it. So there's patents, there's trade secret, trademarks, copyrights.
Right. So basic primer trademarks are going to protect your business name, your product line names, your product names. So that's kind of the triage that I think of. Your company name, this line of products, and then the individual products themselves may each be protected by a trademark. Trademark could also protect a slogan or something along those lines. And then copyright protects anything that can be transformed into a tangible form, written copy, art, music,
books,
websites, motion pictures, anything like that. But the copying aspect of copyright has to be verbatim. So if somebody just copies your idea, that's not necessarily a copyright violation. They have to copy the actual text or the actual music or whatever the case may be.
And so with trademarks and copyrights, at what point should a person come to a lawyer? Are there things they can do in the interim? And I've talked about this a little on the show about, like with copyrights and trademarks, there are some steps you can take that don't cost any money. But at some point, as your business grows, as your brand grows, you should consider really taking the steps of affirmatively protecting trademarks and copyrights. So at what point should a person come to understanding budget?
Right,
too.
I know. And then we're absolutely sensitive to that. The trademark is a little bit easier than patent because there's no bar to trademark from a statutory standpoint. Now, if somebody else starts using your name and they've got prior rights in that name, then that could bar you from getting a trademark. But there's no rule that says once you've been using this name for a year, you can't get a trademark on it. You could have been using this name for 10 years and it's fine as long as you take the steps to register it. So that can basically be done at any point in time. If you have the opportunity to do it in the beginning, right when you're starting your business, that would be fantastic. And the most important reason why is because you don't know what else is out there if you haven't done that research. And so if another company comes in right behind you, or maybe was already in the market before you and you just didn't know that, your rights could be severely limited based on stuff that you just didn't even know about. So we have that unfortunately happen a lot where, a gym owner or a yoga studio has been operating for a couple of years, and they're like, we love this name. We've got the money now. Let's register it. And we can't because there's other issues out there.
Wow.
And so if you can come to us with maybe 3 to 5 names before your business starts, before you open up, before you spend the money on signage, before you spend the money on art marketing, and we can tell you very quickly, like, these are the best from a trademark perspective, and then you pick from that list based on what your personal preferences are. It makes life a lot easier.
That's smart.
I know not everybody can do that, but that is what I recommend all the time. Come to us with 3 to 5 names before you start your business.
Yeah.
We can do that really cheaply. We can do that really efficiently. And then you're not stuck in a situation where you've been spending money on this name for 3 or 4 years and you can't protect it.
Right. Because I think people will Google something and see, I don't find anything on Google. There's no domain name that uses this word or whatever, so I must be fine.
Yeah.
But there's a lot more to it, right? Than that.
Right. Yeah. There's a federal database that we search, and there may be things that pop up on the federal database that aren't anywhere geographically near you, but they still preempt you because they filed first.
Right.
That's the type of thing that we'd be able to find that you might not be able to.
Right. So trademarks are deceivingly complex. It's not as easy as a Google search that kind of thing. And then with copyrights, it's similar, right? That you don't necessarily have to take any affirmative steps. But if you do, there are benefits to doing that too, right?
Right. You can't file a lawsuit until you file a copyright or until you receive a copyright registration. So, if there's something that you think is going to be copied, you certainly want to get a registration on that. If it's, whatever your most valued asset is. If your company's assets are copyrightable materials, then those are the types of things that you want to protect. Protecting your website copy if you're running a guitar shop might not be that important. But if you're a musician, obviously you want to copyright you want to get an actual registration for your music.
And so what about the costs there? We talked about patents and the varying costs. Trademarks, I know, are less expensive. Copyrights are less expensive. But what kind of ballpark range would you give as it relates to costs?
Copyright's going to be the least expensive. The registration process is pretty streamlined. There's not a whole lot of back and forth. So you're probably looking at less than $1,000 to file a copyright application. For a trademark application through registration, probably about $2,500, through the entire process. So dramatically cheaper than patents, but still a cost.
Right.
And that's spread out over years. I should say that's not an upfront cost. That would be spread out over at least a year. Mm-hmm.
So if I'm a new entrepreneur, somebody sitting at home who wants to do something with my IP, and I'm looking at the costs, and I'm looking at, doing it myself, how would you suggest people balance those considerations? Because I think it's easy, particularly with copyrights and trademarks, to look at the website, so the Copyright Office website or the Trademark Office website, and say, oh, this is simple. This is something I can kind of do myself. At what point do you think people should definitely use a lawyer? At what point might they be comfortable doing some things on their own?
I would say have an initial conversation with a lawyer. Find somebody you trust, have a conversation about, okay, I have a limited budget. What are my absolute things I have to do or, highly recommended, and kind of get the lawyer to spell out based on your technology or your invention, because I think it's going to be different. If it's software, it's going to be different from, if it's the next new gadget. It's just going to be a different analysis. Whether you're online or whether you're in a brick and mortar, that might make the decisions different. But there's no lawyer that's not going to sit down and have an initial conversation with you for free, or if not for very cheap, and give you at least some of the guidelines as to, number one, I would protect this. Number two, I would do the trademark search. Number three, and kind of go from there with what you can afford.
Yeah. So great advice there about balancing out and having an initial conversation. That makes so much sense, right? So when people are doing this, and maybe, I don't know if you want to answer this question or not, Nichole, but how do you decide on a lawyer? How do you choose someone to, give what for a lot of people is a lot of money, right? To protect this intangible asset. Do you have suggestions on how to go about finding a good lawyer? Like, I have thoughts about how you go about finding somebody you trust, but do you?
I would be interested to hear what you think after I say what I think.
Okay.
But, I think just based on anything else in my life, I go on personal recommendations.
Yeah.
I ask my friends, I ask colleagues, I ask, who should I use as an electrician? Who should I use as a plumber? Who have you used and had a good experience with? That's how I would go about it. And, people, if they've had a good experience with somebody, are going to refer somebody.
Right.
And so that's kind of how I find everybody in life. I don't do a whole lot of just cold Google searches to find somebody that's really going to have that level of impact on my business.
Yeah, no, I love that advice. So certainly recommendations from people I trust. Though what I have found, at least, maybe not as much now, but some people just don't know IP lawyers.
That's
they
true.
might know a lawyer, but they don't know an IP lawyer, or they don't know, there's actually a specific type of lawyer for this specific kind of thing. And I think that part is hard for a lot of people. And so if you do have to cold call or reach out to people, I'm always interested in the response, just even to the outreach. Like, how long does it take for a person to reach out to me, to reach back out, right, to respond? Are they confusing in the interaction? IP can be really, really complicated already.
It is.
And if I'm sitting across from you and you sound like Charlie Brown's teacher, then it's okay, well, maybe this is not the person for me.
Hope I don't sound like Charlie Brown's teacher today.
Not at all.
No.
But I think those things,
yeah.
Obviously, you're exactly right. If you can get a good referral, certainly. But if you don't know any lawyers, and if you really are just kind of reaching out to people, cold calls, Google, whatever, then those are the things that I think are important.
Trust your gut, basically.
Yeah.
If you have a bad feeling from the start, then that's probably not the right thing.
That's right.
Yeah.
That's right. And with IP in particular, you referenced this, and I love that you did that. With IP, sometimes the costs are hidden or spread out over time. To file the application might be $5,000 or $7,000 or whatever. But then you have to go back and forth with the patent office or with the trademark office. There can be additional costs. There are maintenance costs.
Right.
So is this person being forthcoming with how much the bill is at the end?
Yeah.
I think is important.
Ask those questions. If you have any confusion over anything, ask those questions and expect a straight answer. Yeah,
that's exactly right. And I think, some of our colleagues in the profession aren't always that great with that kind of thing. But those are the things I typically suggest. If you don't get a good referral, or if you can't get a good referral, look for some of that stuff too.
Yeah.
Yeah. All right, so you are in a firm. You've been a partner now, or you've been in the law firm for a while. You were also general counsel for a startup. As startups are growing, how do you decide when to hire an in-house lawyer, bring somebody in? Because you were at a startup, right?
I was. So
and when you just work with a firm, how do you know when to make that choice?
I think that hiring a lawyer is going to come down the road, an in-house lawyer. When I went to work for the company I was working for, I think they formed in 2004, and I went to work for them in 2012. So that's
time.
Yeah, it took time for them to get to the point. And they were beyond needing a lawyer by the time I got there. They could have used a lawyer probably 2 or 3 years prior to that. But I don't think they knew they needed a lawyer. I was actually working for them doing IP work, and I went in and basically was like, look, you guys have a lot on your plate. I can help with that. And that's sort of how the whole thing got rolling. And sometimes people might not even realize that they need a lawyer, or that having a lawyer in-house might make things more efficient. Yeah. Especially for the C-suite people, to take reviewing contracts off their plate, to take managing litigation off their plate, to take things that maybe are overwhelming or outside of their comfort zone, into a place where it's a little bit easier to manage. So
yeah, because I've talked to a lot of startup founders, and I think you're exactly right. They sometimes you just don't know when you make that switch from, I'm going to call this lawyer for this, to we really need help. And when you find yourself reading all the contracts, Googling all of these things,
the terms, right?
This is when you probably need more help.
Yeah. And when I went in, my CEO was basically like, I don't want to ever see another contract again. Got it. Like, that's what I'm here for. So, if you're at the point where you don't ever want to see another contract again, you might need a lawyer. Yeah,
you probably do need a lawyer at that point, right? So a little bit of a different question, because I think this is within your wheelhouse now, at least what I understand about your work. There are a lot of people now who are creating software-based companies or app-based companies. And with IP, software and apps have, there's somewhat of a chasm between what is protectable and what is not protectable. Could you speak a little bit about that, about like if you are creating something that is app-based or software-based, what other things should you be thinking about? Because it's not the traditional, should I get a patent calculus, right?
It's not. It's a much harder decision when it comes to software. Up until about 2014, getting a software patent was just as easy as getting any other type of patent. And then we had some cases that came down in that 2014 time frame that really changed the landscape of getting a software patent. And it comes down to this concept called abstract ideas, and whether your software is actually something that's within the world of what can be patented, or if your software is just an abstract idea. If it's something that just makes a process that a human being would do more efficient, or more cost effective, or if it basically just introduces efficiencies that occur because of the fact that it's happening on a machine, a computer, instead of by a human with hand and brain, then that is really difficult to patent at this point in time. And the pendulum is swinging back a little bit. It's not where it was pre-2014. It's still difficult to get patents in the software world, but it's getting a little bit easier. And if you follow this stuff, there have been bills introduced in Congress. It hasn't gotten anywhere yet. The former USPTO commissioner has spoken out against this issue. It's a big issue within our world. To translate it to the layperson, all I can say is it's just more difficult. It's more difficult to get a software patent for a lot of reasons that don't necessarily make sense. It's a big question and honestly, we get this question more than probably any other, is related to software app-based technology. Can I patent it? And it's never an easy conversation because you have to get over that hurdle before you even look at whether anybody else is doing something similar. And so in those cases, if you have something really concrete, if you're changing the way the computer works, or if there's some sort of transformation of data, or you're using some new processes internal to the software code itself, then you may have something patentable. But if it's more of an efficiency model, it just becomes more difficult. So, not to discourage anybody, but definitely have a conversation with a patent attorney. You may get on a 30-minute conversation and say, you know what, I'm gonna keep pursuing this from a patent standpoint. Not to say you won't pursue it from a commercial standpoint, or I'm just gonna, protect my business model through other means, such as trade secret or that sort of thing. But that analysis has changed a lot in the last 6 years. So.
Yeah, and it's interesting because, like, on the other side, I've probably participated in 5 pitch competitions in the past 2 years, and almost everybody wants a software-based company, or they're inventing a new app or doing something with software. So it doesn't seem like, the startup ecosystem has gotten the memo that this is going to be really, really hard to protect.
It is.
Maybe not commercialized, but really, really hard to protect. And so I think it's good advice to let people know up front, hey, this might be a great idea, but it's going to be really expensive, if and or impossible
Yeah.
to get a patent for or patent around.
Yeah, and some of the advice that we can give in those types of situations where it seems like it's really an uphill battle is, marketing is going to be you've got to be the best one out there. You've got to be the app that's doing this that everybody thinks of when they think of this technology. And basically you have to make your mark commercially through marketing, because you're not going to have that exclusivity.
Right.
You're not going to be able to prevent somebody from creating another app that does the same thing. So yours just has to do it better.
Right. And that part is hard. I mean, that's almost expensive as going down the route of trying to get the patent, maybe.
Yeah.
Because marketing is really expensive.
Yeah.
So if I can switch gears a little.
Absolutely.
Because I think, as I was saying before, not many people know IP lawyers and how to interact with IP lawyers. So what makes a good client for you as an IP lawyer who works with entrepreneurs, startups, large companies, small companies? What's a good client look like for you?
I mean, honestly, a good client is just engaged and is interested in the process. As you know, reading a patent is not fun. If you're not a patent lawyer.
Right.
So if I can get you to really pay attention to what I've written and make sure it's accurate, that's a win-win. Because you tell me what you've invented, I basically write it up in a language that you can barely understand, and then I give it back to you and ask you if it's accurate. And so if you don't read that document, I don't know whether it's accurate or not. I'm basing it on what you told me, but I really, and so like if I can get a client that's engaged, that wants to make sure that this is right, that's looking at everything and checking all the boxes, then I feel confident that we're on the right path. And never any guarantees in the world of patenting, but at least I know we've covered everything that we could possibly cover in this document. And so yeah, I think just engagement and being a little open-minded to the process, because it's a long process, and it is it is not, like I said, it's going to put you to sleep when you read it.
No, that is such good advice. That's interesting, because like my own experience, I think clients feel like, well, you're the expert. You will tell me what is right and what is wrong. But this is maybe one of few places where you really want the client to say, well, what does this mean? Are you sure that this is right?
Absolutely. I mean, terminology, if the definition's not accurate, then that could have huge ramifications 2 or 3 years down the line. And so we really want you to make sure you're not just giving me a rubber stamp, that you're actually like engaged in this process, because we need you. We're defining what your invention is. And so it doesn't matter what your prototype looks like. It doesn't matter what your actual product on the shelf looks like. If we don't define it accurately in this document, we can't prevent somebody else from doing the same thing.
So once you do all of that, once you define everything, once you file the application with the USPTO and all of that, and your client gets that approval, they get that patent from the patent office, their trademark from the trademark office, that copyright from the copyright office, what do you do with it? So what good is it?
You hang it on your wall.
That's right. You hang it on your wall. And I think that's really where the work begins for a lot of people, right? You get that thing, but then you actually have to maintain it. You have to enforce it. You have to police it. So what do you suggest to people once they get intellectual property? It literally isn't just something you hang on the wall.
Right.
No,
you're absolutely right. I mean, there are a lot of reasons to look for IP within your company, within your organization. Being able to exclude others is probably the primary, to be able to basically be the exclusive person that can make this invention, whatever that invention is, and to be able to preclude anybody else from infringing on whatever is defined in that patent. But it also adds value to your company. If you're looking to build a company for 5 or 10 years and then sell it, if you've got IP assets, that could be the primary value of your company, depending on what type of business it is. So there's that aspect of it too. But yes, you do have to maintain it. If you have enforcement issues out there, if there are infringements, obviously you don't want to ignore them. But that's another expense, right? So, the first step is going to be contacting that person to let them know that they're infringing on your IP, whether that's trademark, copyright, or patent. Then maybe you get a lawyer involved to send a cease and desist letter and kind of open a dialogue of negotiation. And if that doesn't work, unfortunately, the next step, there are some procedural steps you can take within the USPTO that don't involve outright litigation. There's some post-grant procedures that you can go through, the details of which are probably too much for your segment today. But you're going to have to engage in some sort of enforcement mechanism, whether that's through the Patent Office or through a traditional litigation means. If you've got people out there infringing, that's how you protect it.
Yeah, you have to be the police too.
You do
on the back end. And the internet has made it interesting, right? Because you can find people more easily, but that means you have to do something when you do find that activity, and that part can be tough.
Right.
Yeah. Well, thank you so much for being here, Nichole. This has been fun.
Really fun. Yeah, good to see you.
Do you have other thoughts you want to leave people with about IP or any other remarks about, or for startups or for entrepreneurs or for, anybody sitting on their couch right now who has an idea?
I mean, honestly, it kind of goes back to the story I was telling at the beginning of the segment about following your gut. And I think I am not a person that is largely intuitive, but occasionally that intuitive pull hits me and follow it. If you feel a pull to do something, there's a reason. There's a reason you're supposed to be doing that. There's a reason you're supposed to be talking to that person. There's a reason you're supposed to be applying to law school or whatever the case is, or starting that business, or, follow your gut.
Awesome. Wonderful way to end the show. Thank you so much for being here. Thank you to all of you for watching and listening. If you have questions about this episode or about other episodes, please feel free to reach out to me at askshonTavia@gmail.com. That's ASKSHONTAVIA@gmail.com. Make sure you subscribe to the show. Make sure you like this episode. Please leave me some comments to let me know you're out there. And I look forward to next week's episode. Thank you so much, Nichole.
You.
All right. Thank you so much for listening to this episode of the Shontavia Show. If you enjoyed this episode, please be sure to like, subscribe, and leave a comment wherever you're listening. You can find me on social media everywhere, Facebook, Instagram, Twitter, LinkedIn, and wherever else, at Shontavia JESQ. You can also visit me at shontavia.com to find a transcript of this episode, along with other show notes. While you're there, please be sure to subscribe to my email newsletter. The information shared in this podcast and through my other platforms is designed to educate you about business and entrepreneurship, and I love to do this work. While I am a lawyer, though, the information I provide is not legal advice and does not create or constitute an attorney-client relationship. The Shontavia Show is a Leverage Incorporated original. The show is recorded on site in South Carolina and produced at Sit and Spin Studio in Greenville, South Carolina. Original music and sound design is by Matt Morgan and Daniel Gregory. Mixing and mastering is by Daniel Gregory. And the video is by GVL Media.